SJC-08733, Commonwealth v. Shane Moffat.
Good morning. May it please the court. I'm Merritt Schnipper here as successor counsel to Attorney David Lewis on behalf of the defendant Shane Moffat. The defendant has tried unsuccessfully over many post-conviction years to obtain evidence supporting his claim that others were present at the scene of and actually committed the murder of Malcolm Howard. He has sought DNA testing on cigarette butts found near the murder scene in an attempt to identify those persons on multiple occasions, but has been denied access to that evidence. He's asked the Commonwealth to request that New York authorities hold one material witness and asked the Superior Court to authorize the deposition of another, but was refused on both counts. He's moved in the Superior Court for post-conviction discovery into the federal government's eve of trial disclosure that Everell Bartlett, his sister's longtime partner and a suspected federal informant, was present at the scene of the crime but has been denied that discovery. He has sought the same information through federal Freedom of Information Act litigation but has been turned away there as well. In short, the defendant has done everything humanly possible to obtain the information he needs to build a post-conviction innocence case and has spent years trying to use legal process to access materials the Commonwealth can likely get with a phone call. We know from the existing record before the court that undisclosed information relevant to this crime is still out there. Now, under this court's precedents, when a Massachusetts state defendant seeks to compel state prosecutors to obtain information or documents from federal authorities, courts must weigh four factors: the potential unfairness to the defendant from the unavailability of the evidence in question, the defendant's lack of access to that evidence, the burden on the prosecutor of obtaining the evidence, and the degree of cooperation between state and federal authorities, both in general and in the particular case. Application of this test to the defendant's case is completely lopsided in his favor. The potential unfairness is massive, as he's been unable to obtain information to corroborate his version of events in an entirely circumstantial murder case. Lack of access is demonstrated by years of fruitless litigation in state and federal courts. The burden on the Commonwealth appears negligible and probably amounts to no more than a phone call or a letter. And while it's not clear how much of a role the federal government may have played in the state prosecution, it's notable that the United States sent the FBI 302 report in question to the Commonwealth shortly before trial, indicating that the federal government was aware of and was tracking the prosecution. It's notable that FBI agents appeared at the defendant's home shortly after the murder, seeking Mr. Bartlett. And it's notable that federal authorities clearly have both a relationship with the third-party culprit and a file on him that includes information specific to this case. In any event, this court has repeatedly said that cooperation between state and federal prosecutors is and should be common enough that the equitable course is to require that the Commonwealth bear the onus of securing federal cooperation in situations like this. That general rule applies to this case, and the court should not affirm this conviction while there are still so many questions left unanswered. If it does affirm a conviction, I strongly urge the court to exercise its power to reduce the verdict to one for second-degree murder in light of several factors: that the defendant was barely 19 years old at the time of this crime, that the facts of the crime itself make it virtually impossible to believe that it was committed by only one person, and that materials already in the record strongly suggest that the crime was orchestrated by the defendant's much older and more criminally experienced brother-in-law. So that concludes my summary presentation. At this point, I would open it up to questions from the court.
Okay, thank you. I'll turn to Justice Gagliano.
Good morning, Mr. Schnipper.
Good morning.
You said that this would corroborate his version of the event. I think that's one of the problems here is the version of the events. Where does this? So the defendant had this, albeit information late, but the other parties weren't part of his presentation. How do you address that as far as relevance goes?
Okay, so there's really three other parties in question. There's the two people that he testified that were present at the scene and committed the offense during his testimony at trial.
Right.
And then there's the third.
And correct me if I'm wrong, the 302 basically says the defendant did it with someone else.
Right, so what the 302 says is that a man named Desmond Wolfe, or Horace Richards, he goes by multiple names, he was prosecuted under the name Horace Richards, but was interviewed as Desmond Wolfe by the FBI. So the 302 material, which is a 9-page document that's redacted except for about 2 or 3 paragraphs, says that during a proffer interview with the FBI, Mr. Wolfe, I'll call him, told investigating agents that Everell Bartlett, the man who is the defendant's brother-in-law, who he contends arranged this entire affair, told Wolfe that he was present for the scene and that he and Shane, the defendant, had, quote, licked a man down, slang for beating a man up, and that he, Screw, Bartlett, had witnessed Shane commit the murder. So now, obviously, on its face, that appears inculpatory to the defendant, but that material does need to be contrasted with the notes provided by predecessor counsel in the appendix of a Wolfe's interview with his counsel several days before the proffer session, in which I think it is fair to interpret those handwritten notes as being read that Bartlett himself confessed to killing the victim and that the defendant was merely present. There's obviously a disagreement between those two sources of information, and it's our contention that full disclosure of that 302 report and other materials in the federal government's possession is necessary to ferret out the truth or to distinguish between those two versions, and then to allow the defendant to fully present his post-conviction case.
Thank you, Mr. Schnipper. I have no further questions.
Justice Lowy.
Thank you. Morning, Mr. Schnipper.
Good morning.
One of the issues that you raise is the lay opinion of Marshall and Wilson.
Yes.
As it relates to the last time that they saw the victim, and that was with the victim being with the defendant, and suggesting that the defendant was the last person to see the victim alive. And obviously, and this is important, obviously those witnesses, Marshall and Wilson, they don't know that because they weren't there, so they weren't recipient witnesses to the murder. So the problem with that is, as I see it, this is what keeps trial judges up at night, is the problem is everybody in the courthouse, in the courtroom, certainly the jury, knows that Marshall and Wilson didn't see who killed the victim, that they weren't there, and this is on cross-examination, there's no objection, and it's palpable how it indicates the witness's bias. So the judge is sitting there in the midst of a murder trial of some length, hears a question, knows it's objectionable, the answer is objectionable. If the defendant's attorney is on a roll, is the judge supposed to say, hold on, let me see at the sidebar, that answer didn't technically comply with the requirements of personal knowledge, it violates the lay opinion rule, and do you want that stricken? No, I don't. Have you had a colloquy with your client about that? At some point in time, looking at that through the lens of the substantial likelihood of miscarriage of justice just ties trial judges up in a knot. What's your response to those concerns?
Well, my response is twofold. First, let me talk about the trial judge's potential approach, and second, just the court's review of it. So with regard to how the trial, I do think, obviously you have a very experienced trial judge there, and presumably she, because it was on cross, was allowing defense counsel to do what he did. Right. I do certainly think it would have been best practice to say, may I see counsel at sidebar briefly, and just simply raise to defense counsel, who, as you note, was kind of on a roll with his examination, and say, we just heard something from this witness that there's no question, and I think we all know this witness cannot have personal knowledge of. It's highly inculpatory to your client. I just want to flag it because I'm concerned about the record and the fairness of this prosecution overall, and if you would like some sort of limiting instruction, or frankly, in order to strike it, I'll give that to you. So I certainly think that would have been best practice, and of course...
Do you really think so? I mean, that's sort of what I'm getting at. The judge, no doubt, knew that the witness did not have personal knowledge as to what that answer was, and if it were me, I would have thought, wow, that was a good answer for the defendant. They might even want to use that in closing argument. Do you really have to interrupt the defense attorney and bring them over to the sidebar and say, geez, this is going to be reviewed under substantial likelihood. I think I'll just intrude, or at some point in time, do you just have to let the lawyers try the case and let something like that go?
We have to strike a balance between those two things, I think, but the concern here, I think, is that it's very difficult to believe that defense counsel was simply in the flow of saying, well, this just is a great demonstration of bias, and the reason is that there was plenty of demonstrations of bias in particularly Mr. Marshall's testimony without regard to that specific statement that he was the last person who saw my cousin, this is the guy who killed my cousin, because he's clearly already indicating his belief, just through his recitation of the entire story leading up to the time that they departed for the drug deal and his attempts to locate his cousin after they had returned from the drug deal without Mr. Howard. Mr. Howard, sorry. So I think there's a balancing act to be...
But that manifests their bias. See, these witnesses on the witness stand who don't know who committed they don't know who committed the murder. It demonstrates their bias that nonetheless they want to let the jury know who committed the murder. I mean, you got to take everything they say there with the understanding that these are agenda witnesses.
Fair enough, but when you have an agenda witness who's being presented to the court to the jury in the context of a prosecution by the Commonwealth that, essentially is validating, sort of putting the imprimatur of the government's belief on what they're saying, I think that having somebody, it's not really a lay opinion, it's a lay statement of fact that's not known personally, that I think, you're correct that there's a balance that needs to be struck between letting lawyers try the case and the judge superintending it. But in this particular case, I do believe that saying this guy who killed my cousin simply its utility in terms of illustrating a witness's bias pales in comparison to its assertion of a fact that in fact no one at that trial at all is in a position to assert on the basis of personal knowledge.
Yeah. Well, I have to say, you hear that answer, and the judge is going to know it's worse than impermissible lay opinion. It goes to the ultimate issue in the case, and I have to tell you that sitting there knowing that and hearing that, I would not interrupt the defense attorney in the cross-examination, and that I just would assume that the Supreme Judicial Court would understand what was going on. But
when the Supreme Judicial Court reviews, this court reviews, it does so basically without regard to a specific error and more in tune to the idea that we look at the performance of the court, of the prosecutor, of defense counsel, of everything that happened, and we assess the overall impact on the jury's determination. And I think in this particular case, where there literally is no direct evidence of what actually happened, the victim was killed, having a statement, this is the man who killed my cousin, is pretty powerful stuff.
All right, let me just have one other area of inquiry. It follows up with a little bit on what Justice Gaziano was talking about. We've got an issue of whether or not Mr. Bartlett, who I think is referred to at trial as Screw.
Correct.
Whether Mr. Bartlett might be the third-party culprit.
Yes.
And the challenge, and this underlies the whole issue, I think, of the discovery rulings by Judge Page and ultimately by another Superior Court judge. the defendant testifies and doesn't mention Mr. Bartlett. The defendant gives three different versions of events that evolve as he hears what information the police actually have. And none of those three events mention Mr. Bartlett. So that sort of permeates in a lot of ways some of the discovery rulings, perhaps, and also is going to help us address, I think, the 302 report and also the ineffective assistance of counsel and substantial likelihood as well. So why don't you tell me, if you could, please, why that circumstance of four versions of events, the last one being at trial, don't box the defendant in on those various grounds for appeal?
Sure. Well, what I would say is two things, and you're correct that his story evolves as he learns more about what information the government has, and I would ask the court to at least view that from the perspective of a person who has some level of awareness that a person who's both a violent and dangerous criminal and a person who's intimately connected to his family, who's the common law husband of his sister and has three children with her, who's the father of his nieces and nephews, that the intimate sort of relationship that individual has with his family is a credible basis to believe that while he would try to twist and turn to tell as close to the truth as he could get, as information begins to emerge, he's going to feel a real fear of raising the name of the individual who actually has direct knowledge of and access to his family. But one thing I would point the court to is that the very first version of the events given by the defendant that the police obtain is through their interview with his brother. They interview his brother in September of 1999 in New York City before they actually go and speak to the defendant himself down in Florida. And based on that interview, the defendant's brother recounts a visit with the defendant in June of 1999, in other words, 1 month after the murder, in which the defendant does tell his brother, an individual in whom he can reasonably be expected to confide and who is, of course, also familiar with Mr. Bartlett. He tells his brother in June of 1999 that Mr. Bartlett ordered the murder, used the defendant to bring the victim to the murder scene, and had two men brought from Jamaica to do the deed. And
I guess the key to that point, which is you're right, is important. I guess the key to that point is when's the first time the defendant's brother indicated that conversation about Mr. Bartlett being a perpetrator? When did that occur?
The brother said that in September of 1999, which was, I believe, before the police went down to Florida to meet with the defendant in custody at Miami-Dade.
Right. And obviously it goes without saying that what the brother knows is what the defendant shared with him.
Absolutely, and that is noted in that police report on that interview, which I can tell you is located at pages 152 and 153 of the first volume of the defendant's appendix. So, yes, of course, he only knows what the defendant has told him, but of course, the police are reciting only what the defendant has told them as well. Obviously, they have their own sources of investigation as well, but if we're lining up the stories that the defendant has told and saying, wow, well, it's kind of evolving as he learns more about the facts that the government has in its possession, and he never mentions Mr. Bartlett until, lo and behold, this 302 report shows up. Well, this is an indication that that's actually not the case. Now, of course, I'm not disputing the fact that this is only, what the defendant chose to tell his brother, but the timeline suggests that he was talking about Mr. Bartlett's role in setting up the crime before he had ever had any inkling that there was a 302 report out there, and actually before that 302 report was created, I believe.
Okay, thank you very much.
Thank you.
Justice Budd.
I don't have any questions. Thank you.
Yeah, I've got a few questions. At trial, I guess he says that Aya and Quentin were with him, correct?
Yes, I mean, they drove in a separate car, but they were there at the crime scene.
Right. So, And Quentin, he said, was the person who actually did the shooting.
Right.
Did he make any mention of Mr. Bartlett or Screw during the course of his testimony?
He did not.
And is the claim now that it was not Quentin who shot him, but that it was Bartlett who shot him?
The claim is basically that Mr. Bartlett is, the organizer of the crime, and that the two men known by their nicknames or first names are the ones who carried it out. So in other words, that there were four people present: Mr. Moffat, who was used to bring the victim to the scene, Mr. Bartlett, who was basically the organizer of the crime, and the two men brought from Jamaica to commit it at his direction.
Now, at trial, I'm trying to remember, there was not a joint venture instruction given because the defendant objected to it?
Or the defendant did object to it.
What were the grounds for the defendant objecting to it, since he claimed that because he had said that he had no idea that there was no evidence of a joint venture apart from what he testified to?
Well, the only evidence of the presence of any other people, other than by inference of the fact that, a 6-foot-tall and 250-pound man was apparently moved down a hillside without trampling any bushes or anything, the only evidence of the presence of anyone else was his own testimony, and his own testimony did not contain any indication of, cooperative action with these two others. I mean, I suppose theoretically you could argue that the fact that they just arrived in two cars meant that the jury could infer, some sort of participation, but because the only evidence relating to the participation of more than one person presented at trial was from the defendant's own testimony, I think that was the basis of his objection, that the government had introduced any evidence of that he was working collectively with anyone else to commit this crime, and he had not introduced any evidence to that effect either.
Now, part of as I understand it, the only basis to believe that Mr. Wolf or Mr. Richards, whichever name he's choosing to use, identified Bartlett as the killer as opposed to the defendant was based on the notes of the attorney from the law firm in Connecticut, correct?
Yes, Robinson and Cole.
And I assume we know who the attorney is, do you?
I personally do not. I can certainly provide that information through affidavit from Mr. Lewis, who obtained the notes, and provide it for the court.
And I guess my question is, why not just speak to that attorney?
Yeah, that certainly should be done, and I would like the court, obviously I, have to beg off a little bit because I came into the case fully briefed to get over for argument, but I do think that, certainly before affirming any judgment, setting, an order directing us to follow up on that would make a lot of sense. And certainly I'd be happy to handle that. But
generally, I mean, it's been years since this occurred, and if the claim is that the notes of the attorney fundamentally change it, again, it's not on you. I appreciate your taking the case when defense counsel, I believe, is now with the DA's office and stuff, is that correct?
Correct.
But generally we don't order a defense counsel to conduct investigation. It's sort of a strange posture for us to be in. But what are you asking us to do in that context? I mean, my own gut list says, well, you can go speak to the Robinson and Cole attorney and see what he or she has to say as to what her notes reflect, or his or her notes reflect, and then we'll consider it from there. But you're sort of saying that the government has to furnish...
Well, what I'm saying is that when you contrast the contents of the 302 report, which I think we can all agree is extremely heavily redacted, in order to only furnish the evidence that's directly inculpatory of Mr. Moffat, and then we contrast it with some handwritten notes that, are from Mr. Wolf's counsel, several days before that interview that I think read in plain English appeared to show Mr. Bartlett identifying himself as the perpetrator, and in a context where I think we could expect Mr. Wolf to be speaking more frankly because of, the confidentiality that he was enjoying there. That certainly creates enough of a juxtaposition between the 302 report and the attorney notes to justify the discovery from the federal authorities that the defendant is seeking, because it calls into question the idea, and this is the basis of the government's, multiple objections to assisting with this discovery, is that, well, why on earth would this be the basis of some sort of new trial claim when this is just so wholly inculpatory, because it's basically a direct statement of a witness who would apparently, if he came before the court, claim that he saw the defendant commit the murder himself. It calls into question the wholly inculpatory nature of that evidence, because it seems to provide a contrasting version that there's reason to believe might be more frank.
And why do you think there would be another version? I mean, the Commonwealth, I assume this essentially was either a proffer as to a potential cooperating witness, or maybe even a CI, and
it's many topics.
Former. Sorry?
It's the former, yes. It was I think, part of his proffer before he ended up pleading guilty.
Okay. And there may have been many other areas of inquiry, I gather.
Well, there may have been, of course, because it's fully redacted. We have no idea, and we obviously, as you are well aware from the voluminous record in this case, have pursued that all the way to a cert petition to the U.S. Supreme Court with regard to the Freedom of Information Act aspect of things, to file multiple Superior Court motions for post-conviction discovery. I mean, there's been 2 attempts to obtain DNA testing. I mean, there has been, I think we can certainly agree, and sort of no-holds-barred attempt to access additional information showing who may have been present at this crime scene other than defendant over a number of years. So, I mean, certainly the effort has been made. The question remains what's in the report. It's very hard to say that the door should be fully closed on discovery based on the fact that the denial of the discovery has been so fully effective.
Okay. I have no further questions. Justice Lang?
Yes, I have a couple. Good morning, I think.
Good morning, Justice Lang.
Now, the first one has to do with the fact that I know this is not your brief, but do you adopt all of the arguments in the brief?
I'm here to defend them as best I can.
Okay, because you went immediately to the second one, which is to do with the erroneous denials of his motion for a new trial, right? And for discovery as your primary argument, right?
The primary argument is really that he's entitled to the discovery of these materials so that he can build his new trial case.
Okay, yes, but I mean,
that's how I read it.
Yeah, okay. So it's to build it, not so much that they erred in denying the motion for the new trial.
I think it's very difficult to say that on this record. What I think is much easier to say is that there's a justification for the investigation that he's been trying to make for many years.
Okay. And how does that relate to the first contention, which is that the Commonwealth's presentation of a theory of a case it knew or should have known to be false was somehow the reason that we should vacate the conviction?
I think there's a concern here that the government was making an argument to the jury that was predicated on the idea that this was orchestrated completely by the defendant, when it had significant reason to know that he was not the only one there, right? That he was, even if you accept their theory that he was a full participant in the crime, that he was working with somebody else. We at this point don't know how much information the government may have had from the federal authorities about the role of Mr. Bartlett, the believed federal informant and orchestrator of the crime. But I think it's certainly the case to have information in your hand that you know shows, at the very least, that someone else is present, and then to mockingly refer to the other people present as mystery men and figments of the imagination. I think, is it presentation of false testimony? No. Is it arguing a theory that you have reason to believe is not wholly correct? I think it is.
Well, I mean, what are you saying that they think was not fully correct? I don't understand that. What knowledge do you think they really had about who it was? What were they supposed to have done instead?
Well, I mean, as counsel suggests, they should have investigated these allegations to try to figure out whether there indeed was some sort of joint venture to commit this crime, because that, of course, could have either resulted in a fuller presentation of the truth to the jury, or it could also have, potentially shown that their theory of prosecution was incorrect and that the defendant was either actually an innocent bystander, as he contended, or some sort of dupe who has played some sort of lesser role, either of which would be a finding that would mean a first-degree murder conviction was not consistent with justice.
Okay, I think this is connected to this in some way, but maybe I misheard you, but I thought that earlier you said the crime could not have been committed by one person. I would like to know why you think that, if that was right. Did you say that?
I did say that, and the reason I said that is that the facts of the location where the crime was apparently committed and the victim's body was definitely found, show that, there was either one or two cars. We don't know at this point. The victim was shot in the side of his neck while sitting in the driver's seat of a car. His body is then found down at the bottom of an embankment on the side of a rural road with no signs of trampling or damaging of the undergrowth beyond which he's found.
So much you infer what? What do you infer from that?
I infer from that more than one person carried his body to its resting place, and he's a 250-pound man. At the time, the defendant was 19 years old and is a person of very slight build, and simply was not physically capable of moving a large dead person's body to that place without just dragging it and causing a tremendous amount of destruction along the way.
And you say that it's very clear that there was no destruction. That's really the reason why you think it couldn't have been committed by a woman. Because the location and the fact that he was shot, those things are not particularly persuasive to me. But,
right, but if you look at then, counsel, Mr. Lewis has presented in his brief very clear color photographs of the scene taken by the police when they recover the body, and you can see that the, significant sort of 20 or 30 feet of brush and undergrowth is not disturbed between the roadside and the resting place.
Okay. All right, thank you very much.
Any further questions of any of my colleagues?
Yes, please, Chief.
Mr. Louis?
Thank you. Mr. Schnitzer, on the point of Mr. Richards, when you say that, this information that he knew that somebody else was present, Mr. Richards, who is making the statement to the lawyers in Connecticut, he wasn't there. He's saying what somebody else said, correct?
Correct.
And not only is he saying what somebody else said, but what we have here is the defense attorney getting this information about the 302 report, and it shouldn't have been a week before trial, but getting this information about the 302 report, and what the trial attorney has is information that's inculpatory of his client, and we don't have an affidavit from trial counsel that's part of the motion for new trial or even the motion to reconsider. Now that certainly is important on the ineffective assistance of counsel claim, but does that situation relate at all to some of your other arguments about Screw, Mr. Bartlett, thank you, being the perpetrator, or at least the kingpin, the organizer?
Well, I don't think trial counsel would have had any particularized knowledge of those facts, but he would have been able to explain why he either chose not to try to investigate more fully the contents of the 302 report, or didn't seek to continue trial for purposes of figuring out what the relevance of this information actually was. I think it may be fair to assume that viewing it as the court appears to, and I can't disagree that on its face it's inculpatory, and why would you say, well, in addition to this circumstantial case the government already has, why should I go up and try to see if I can actually find the eyewitness who says he saw my client commit this crime? But that's why in the post-conviction investigation that should at least cast some question on the validity of that assertion. And I do think trial counsel should have probably been aware of the fact that there was an interview with the defendant's brother, in which the defendant's brother communicated to police well before trial that the defendant had told him that Mr. Bartlett actually was the organizer of this crime. Obviously the Commonwealth had that, and I think that goes into what Justice Language is asking about whether there's reason to believe that the Commonwealth presenting a case that had, a good cause to believe was not fully the correct vision of what happened.
Well, I'm going to ask the Commonwealth about that, but I guess my point is that, as you well know, this is what you just outlined is a pretty difficult road to hoe when there's no record in a motion for new trial on an ineffective assistance of counsel claim. It's now been litigated before the Superior Court.
Fair enough, although it certainly was not granted a hearing at which such evidence could have been more fully explored. But you're right, there should have been an affidavit from counsel explaining his thinking in there.
But when there was a motion for reconsideration of the denial of the motion for new trial, that wasn't added as a grounds, the ineffective assistance of counsel.
No, it was not.
Okay, thank you.
Any further questions? And hearing none, Mr. Schnipper, thank you, and we'll turn now to Ms. Payne.
Thank you.
Thank you. Good morning. May it please the Court. Assistant District Attorney Cynthia Payne on behalf of the Commonwealth. On May 13th, 1999, Shane Moffat brutally murdered Malcolm Howard at close range with a shotgun blast to his neck, severing his jugular vein and carotid artery. The Commonwealth's theory of the case was that the defendant acted alone when he killed Malcolm Howard, and the Commonwealth presented substantial evidence that supported its theory. That evidence included the defendant's presence at the crime scene, his papers and fingerprints in the car in which the victim was killed, the defendant's boots with the victim's blood on them, the defendant's bloody T-shirt, the defendant's use of the victim's cell phone close to the crime scene after the murder, the defendant's prior purchase of shotguns from the person he tried to call after the murder, the defendant's admission to the police that he owned the murder weapon and that he split the barrel from the shotgun and disposed of it in the sewer in Hartford with a friend after the murder, the recovery of a shotgun barrel in a sewer in Hartford, the defendant's flight to Florida and use of alias, and the defendant's multiple lies to people, multiple statements to police, and evolving story to explain away the evidence. The FBI 302 redacted report given to the defense approximately 6 days prior to trial consisted of inculpatory double hearsay in which someone named Screw claimed that he saw the defendant kill the victim. This report, which was dated December 9th, 1999, supported the Commonwealth's theory that Moffat acted alone when he killed the when he killed the victim. I'd like to correct an error in the Commonwealth brief on page 37 brought to my attention by prior appellate counsel. The United States Attorney Office in Hartford, not the FBI, sent the 302 report to the Massachusetts State Police. Howard's murder was not investigated by federal authorities. Any investigation regarding Horace Richards was the subject of the FBI 302 report, or the individual named Screw, or Mr. Bartlett, was unrelated to Howard's murder investigation. The defendant makes much of the fragmented, handwritten, vague, and semi-readable notes which appear to have been written in January 1999. He attributes these notes to Horace Richards' prior attorney, but never provided an affidavit or any type of authentication. These notes do not support defendant's claim of innocence. These fragmented, handwritten, vague, and semi-illegible notes were written prior to the formalized, typed, and clear 302 report. Trial counsel was not ineffective. His decision not to investigate the inculpatory FBI 302 report was not manifestly unreasonable and did not deprive the defendant of a substantial ground of defense. Trial counsel hired 3 investigators and requested funds on 3 occasions during the pendency of this case. The defendant included an affidavit with his motion for new trial filing from an investigator who claimed he was unable to investigate the 302 report accurately. However, despite the defendant's voluminous filings, he never included any affidavit from trial counsel, nor did the defendant, through any of his appellate counsel, even indicate he had attempted to contact trial counsel for an affidavit. Moffat presented his version of the story to the jury, who rejected it by finding him guilty of first-degree murder. That Moffat disputed testimony elicited during the Commonwealth's case did not render that testimony false. None of the defendant's claims warrant reversal. The jury's verdict of first-degree murder is consistent with justice. Thank you, Your Honors. I now invite questions.
Okay, Attorney Justice Casiano.
Thank you. Has the defense cherry-picked from the Connecticut lawyer's notes? What else is in there that would call into question these assertions?
Well, the notes, from what I could read, which I find really difficult to read, they reference clearly a different murder would indicate the victim was shot 4 times, was shot in New York. So clearly he has picked what he wants, but I think it's not clear from those notes, which again predate the FBI 302 report. It's because it's written in shorthand. You don't know it could refer to Screw, it could refer to the defendant. I think that's why we go to the FBI 302 report, which clearly states he, and then in parentheses, Screw, observed the defendant kill the victim. Did that answer your question?
It does. Thank you. Those are all the questions I have.
Thank you. I guess my first question goes to the issue that Mr. Shipner was raising during argument, which was is the Commonwealth sitting back and not only allowing some testimony that might not be true, but inappropriately sort of scoffing at the defendant's theory that somebody else committed the crime, referring to these people as mystery men, and at the same time that they know there's a 302 report that indicates that somebody else was present there, and they understand perhaps. Well, I'll leave it at that. Is that sort of disingenuous in the closing and concerning?
Well, I would say what the 302 report says is that Screw observed. So it doesn't give. There's no particulars. It doesn't. I mean, he could have been, 50 feet away. So we don't really. I would say it's not disingenuous. And I would say in regards to the ADA's closing, analyzing it in the light of his entire argument, that was the mystery men was a small portion. And I would suggest the fact that the defendant refused to provide identifying information. In fact, they were mystery men, and I do know that at one point, I think the last time the ADA references the mystery men, he says, because they didn't exist. Well, I would suggest that maybe this was a little over-enthusiastic rhetoric, but in light of the ADA's entire closing, in light of the fact that the defendant refused to identify these people, he claimed he knew who they were, but he refused to give identifying information. I don't think the prosecutor's closing was just disingenuous.
Now, did the defendant testify that the reason he wasn't doing so is because he was in fear of his safety?
He did.
Okay. I guess the concern about the mystery men comment is not that it's what we sometimes refer to as enthusiastic, but not error. It's that the prosecutor had a week before trial an indication that might not be true. I understand Mr. Richard might not have told the truth, but they've got some information that there was somebody else there.
But I would note that... Oh, I'm sorry.
No, please. Go ahead.
I would note, defense counsel did not object. So I think that speaks volumes to the fact that he didn't object, that the prosecutor's closing did not go outside the realm. And even if this court were to consider that error, I don't believe that it would be error which would have influenced the jury's conclusion.
Okay, let me ask you another area involving the closing. This is my last area. The comments about Stone Cold Killer seem to reference, perhaps the Commonwealth could say, seem to reference something about the defendant's demeanor on the witness stand. But it also, when you call somebody a stone cold killer, and it's not about the manner in which somebody was killed, it suggests in infusing character evidence into the trial. So, do you think that the stone cold killer was permissible closing rhetoric? Let me start with that.
Your Honor, I don't believe the prosecutor ever stated stone cold killer. He clearly stated, I believe it was 6 times, stone cold, but never said stone cold killer. I believe in the beginning, when he said it was pretty stone cold, throughout his testimony, he didn't slip. It was pretty stone cold, but he danced a little when he talked about the cell phone. So I think that certainly was in reference to that he knew what the defendant knew what he was going to say, and he knew it really well. But then when it became a little problematic that the cell tower, which picked up his phone call, was within 3 to 5 miles. I think that was very, very much supported by the evidence. I think at one point,
if you look at when we look at the closing carefully, you think that we'll interpret the reference to stone cold not the manner that the Commonwealth was arguing that the defendant killed the victim, but the defendant's manner and demeanor on the witness stand and the manner in which he was able to lie, including admitting lying, I think, to one of the other witnesses.
It was clear that and this defendant admitted when he testified that he lied to multiple people. He lied to the police. He lied to his family.
I understand that. I reference that to ask you: is it clear in the closing that that's what he's referring to, and not referring to the manner in which the Commonwealth was arguing that he killed the victim?
I will say that there was the last time the prosecutor referenced he was stone cold. It did go. He said he was stone cold, just as stone cold as the killing and death of Malcolm Howard. But I would suggest the fact that he was referring to the defendant's demeanor on the stand and his ability to lie, and it wasn't that he was a stone cold killer, because he never used those words, stone cold killer.
Okay, thank you very much.
Justice Budd.
I'm all set. Thank you.
Just a few questions. What was the Commonwealth theory, or the evidence as to how the body of Mr. Howard was dumped down the hillside?
Well, my understanding is that the car was parked with the driver's side next to the woods. The driver's side would be where the victim had been sitting. The testimony with it was a very steep embankment. There was also testimony that when the victim was found, 3 days later, he was covered with debris. So I think the fact that 3 days have gone by, this is May, this is a time when things are growing at a quite rapid pace, that I don't think the pictures quite do it justice, but I do believe that the testimony was this was a very steep embankment, and I would leave it at that, Your Honor.
So the theory would be that the car was parked towards the edge and he was just basically pushed out of the
Correct.
car, just rolled down the hill.
Correct.
What did the defendant say? I've not gone through his testimony. What did he say as to how he ended up after a killing, which he said he was stunned by ending up with a shotgun?
I believe he told so many different, you mean in the version?
At trial. I assume he was questioned about the disposal. I think he admitted that he managed to get rid of the shotgun, didn't he?
I believe that he claimed that, so he denied owning the gun that killed the victim. He claimed that his friend, Jared Thompson, had a shotgun, and he advised Thompson that he really shouldn't have it in his house because this victim was killed with a shotgun. So it was a little bit muddled in the testimony, but I believe he and Thompson both testified that it was pipe was dumped in a storm drain.
It was a different shotgun than the one that was used, or that?
But it was right, correct.
Okay. And were there any? Were there any forensic evidence to indicate that was the shotgun that was used in the killing, or is it too hard to do it with a shotgun as opposed to a? It
was too hard. I believe the expert indicated that the wadding and what was recovered during autopsy could have, but because of the shock and the fact it was cut down, they weren't able to definitively. He could not say that it was that barrel.
Okay, I have no further questions. Justice Lang.
Now, I have a question having to do with 33E review. Just quickly, in his closing, the prosecutor also remarked, quote, "The defendant's seen all the evidence and testified certainly consistent with what the evidence was that was presented. It's a lie with a twist," unquote. Don't you think that's an improper comment? That he was telling his testimony the evidence at trial?
I think in light of the fact that the defendant admitted that he lied numerous times, that he lied to his family, that he presented numerous versions of what had happened to the police, I think the prosecutor was entitled to maybe not say that he was able to sit here and tailor, but I think what the prosecutor said did not rise to the level of reversible error in light of the prosecutor's entire closing, and certainly in light of the judge's numerous instructions. I believe she instructed the jury immediately prior to closings that closing is not evidence, and then during her final instructions.
Okay. Can we talk about the instructions? Because I think we have to, the defendant is saying...
We're having trouble hearing, I think.
I'm sorry, I had my paper over the telephone. I'm sorry. Can you hear me now?
It's better.
Okay, thank you. The defendant is complaining about the instruction that the judge gave concerning circumstantial evidence. What do you have to say about that?
Well, I would suggest that there was no error in the judge's final instructions. She properly defined both direct and circumstantial. She gave examples of both using the mail carrier example. She correctly defined inference and indicated that inferences must be reasonable. She gave examples of what an inference is. And I think in light of her entire instructions that there certainly was no substantial likelihood of miscarriage of justice.
Okay. All right, thank you. That's all I have.
Any further questions of the justices of Ms. Payne? And hearing none? Sorry, was there a question? Nope.
No, thank you, Your Honor.
That concludes the argument, and we shall commence our ensemble on the case at 12 noon. Thank you so much.
Thank you.